Welcome to the Supported Living Property Podcast with your host, me, Lisa Brown, the place to learn about supported living property investing. Hi Suzi, it's great to have you here today. How are you?
Hi Lisa, yeah, I'm great, thank you. How are you?
Yeah, no, I'm good, thank you. For people who don't know you, Suzi, do you want to introduce yourself and tell people a bit about you?
Yeah, sure. So hi everyone, it's a pleasure to be here. My name's Suzi Carter. So I'm a chartered surveyor. I've been in and around commercial property for almost 30 years, scarily. I've got a commercial corporate background. So I've worked for kind of a lot of the a lot of big corporates in the commercial space. So CBRE, B&Q, Land Sec, where I manage big portfolios of commercial real estate. I actually stopped the corporate world. I gave up the corporate world in 2015. And now I do some consultancy for clients. I run the Commercial Property Academy, where I kind of help people invest in commercial real estate. I invest in both residential and commercial property for ourselves. And it kind of never looked back, that's for sure.
Fantastic. And obviously you're here today because I want to pick your brains about leases, because obviously with all of that, your experience in all of that commercial property, you're very, very familiar with commercial leases. And for a lot of people, a lot of property investors come into this space and a lot of providers, leases are something a bit new that people have to get their heads around, and I think there's a lot of confusion about them. First of all, if you don't mind, what's the difference between a lease and an AST? Why can't you just have an assured short hold tenancy if I'm a care provider, taking on a property?
Yeah, so a commercial lease is put in place to a business. So you can't put a assured short hold tenancy or residential tenancy in place to a commercial entity, to a business. So you have to have a commercial lease to a business, and therefore it's governed by a whole different set of legislation and case law, which governs commercial tenancies, basically. So it is a completely different world than residential ASTs.
Fantastic. And obviously you spent most of your life, I guess, from your experience, or a lot of it, talking, negotiating lease terms and being very familiar with all these different lease terms. What do you think people need to think about when they are negotiating leases? What's key when you're negotiating them? Because they're not set, are they? Like an AST is fairly standard and this is how it is. Leases aren't like that, are they?
No, that's right. So it is definitely all down to negotiation. But the best place I would start is a heads of terms. So because commercial leases can be a bit more complicated and also are not set in stone like ASTs, it's a really great place to start is to put heads of terms in place. So, landlord, tenant, property, lease term, how long is it going to be? Are there any break clauses in there? What's the use of the property? Because that needs to be governed, and you would usually say within a certain use class or type of use, there'll be some restrictions as well on use. If you don't want certain types of uses in there, then who does the alterations, who insures, are the alterations structural or non-structural, so a really common type of commercial lease is a full repairing and insuring lease, where basically the commercial tenant is responsible for the whole term of the lease for repairing the inside, the outside, the property, very hands-off for the landlord. You can't always get that. So you may have to kind of row back on that and maybe have some form of service charge, or the landlord responsible for certain elements of repair. Then, kind of in terms of can the tenant assign their lease or sublet their lease? There'll be kind of governance around that. Are there any rent reviews? Because one of the beauties of commercial leases is that there's the ability to keep track with inflation, the rent to keep track with inflation, because obviously they can be longer leases. So is there any provisions there for reviewing the lease, kind of increasing the rent or decreasing the rent? You're trying to avoid that, obviously. And yeah, so and then, you know, kind of what is the agreement subject to? Is it subject to planning? Is it always subject to contract, but is it subject to, you know, board approvals or whatever else? And then some timescales in terms of that happening. So I would really recommend people start with some heads of terms, which basically give some broad principles in terms of an agreement, so that when you actually instruct lawyers, because you will need to instruct lawyers to do the lease, well, you know, you're not spending a lot of lawyers' time trying to negotiate those kind of heads of terms. The kind of principle of the agreement is agreed.
That makes sense. It's basically you sitting down with the other party and just agreeing, coming up with a list of things that you agree with and you want to put within the lease. That's essentially what heads of terms ends up being, is it?
Yeah, so if you Google heads of terms commercial leases, you can see some kind of draft, and the landlord would usually come up with the first draft of it and then send it through to the tenant, and then the tenant would you know, come back with their alterations. Then you kind of get to some form of agreed position before you instruct lawyers. Yeah.
And obviously some of the providers, some of the bigger providers will have a set lease, that this is the lease that they use, and they'll present that to a property investor, and you won't necessarily be able to do that and write your own lease in that way. But certainly with some of the smaller providers, they might be more flexible in lease terms and be open to those kind of negotiations. So it's really interesting to understand how that works and how that process is. You mentioned break clauses when you were talking then. What kind of break clauses, or what is a break clause really?
So yeah, a break clause is when, so obviously you have the term of the lease. So say the lease is for 10 years. A break clause is the ability for one or both parties to terminate that lease early. Now, you can have a tenant's break clause where the tenant has the ability to terminate early, and that there might be some conditions on that. It might be that, you know, they can only terminate for a certain reason. Or quite often there's timeframes in there as well. So, for example, they might say the lease might say only on 6 months' notice, notice to be served by, you know, mail or whatever. So there's quite tight provisions in there, so that if they haven't served that notice in time, they lose their right to break. Or it could be a landlord's break clause, or it could be a mutual break clause where either party has the right to break at that particular time. And I know that some banks do like to have break clauses in some of these leases because they're worried about the reputational damage of having to remove kind of, you know, residents there who with support needs or whatever. So I would think that you'll find a fair amount of break clauses in these kind of leases. I suppose the only thing to say in addition to that really is that if you've got a 10-year lease with a tenant's break clause at year 5, it isn't actually a 10-year lease, it's a 5-year lease. And so when it's being valued, a valuer won't look at it like a 10-year lease, they look at it like a 5-year lease. So commercial agents, in my experience, if they're marketing that type of property, they quite often fail to make that differentiation. So you just need to be smart to that as a point.
It's really, really true. And so when they're looking at that valuation, is that regardless of which side the break clause is on? If the break clause is on the landlord's side, do they still value that up as a... No.
So if it's on the landlord's side, obviously it's at your discretion. So if it's mutual, they would do, because if either side could do it. If it's landlords, no, they would tend to look at it as a 10-year lease, because you know, you would think that you're only going to do something that's within your commercial benefits, and if that was, you know, why would you terminate it early? Then there might be a reason, because you want to redevelop, in which case that's fine. But you would usually just assume that's a 10-year lease in that case.
Yeah, and certainly you're right about the lenders wanting to have break clauses. I've had to put those into leases, you know, where if I was to default on payments, they wanted, you know, to be able to break and in their favour if I was to default paying, so that they could repossess the property if they needed to. So absolutely, that's definitely something. Yeah, which I have to say, from a commercial perspective, I completely understand that their perspective, but equally I would think that from a lending point of view, you would also actually want a longer lease. So having kind of these break clauses in there from a commercial perspective gives you less certainty potentially. So it's, I don't know, I understand it on one level, but I don't understand it on the other. No, it's really complicated, isn't it? And I think, and again, most of them, the lenders on the residential properties won't like leases longer than 5 years, which again doesn't seem to make a lot of sense when, if someone wants a longer lease on the property, most property investors would rather issue a longer lease, and then you're having to say, oh, sorry, my bank won't let me do that. I want it at least to be 5 years.
Yeah, which in the commercial world is crazy, because if a tenant says to you, I want a 10-15 year lease, you're never going to say to a commercial tenant, oh no, actually let's just do 5, it's fine. It is really about faith in terms of what you would usually expect.
And the commercial lenders are obviously happy with those longer leases.
Yes, exactly. Yeah, in fact they will feel a lot more comfortable. Obviously they'll do a tenant covenant check, so they'll make sure that you're not just giving a 10-15 year lease to an empty entity and they're going to go under in 2 years. So they'll make sure of that. But as a general rule, the longer the lease is, the more they feel their risk is mitigated. So, they feel much more comfortable with it.
Yeah, it is really interesting that they try and, it's different on a building that's classed as a commercial building, like a larger block of flats or a large HMO, but a small residential property with a commercial lease on, they're literally always wanting 5-year leases. It's definitely, it's interesting. And I think it will change. And I think it is a changing market as the lenders understand the space a bit better. I think it will be interesting to see where it goes. So you've talked about break clauses that can be in favour of either side. Is there anything else that can trigger break clauses? Is it just one side or the other deciding that they want that?
Yeah, so you can have so in terms of actual break clause in the lease, you can have penalties on there. So if one side operate a break clause, there's a financial penalty. There can be break clauses if they haven't fulfilled certain things, or it could be for a certain reason. So that's the main thing. You can't tend to break for any other reason than is stated in the lease. If a tenant is defaulting on their rent or they're not repairing the property, there's other grounds where you can move a tenant on, or try to move a tenant on. The law is very much on the tenant side in that kind of sphere. But you'd have to use different provisions in a break clause to do that.
So it's really key to get those break clauses right, and obviously to get good legal advice when you're writing these leases to make sure you're protected in the way you need to be.
Yeah, absolutely. Yeah, and I don't know how much ability you have to negotiate some of these leases, but I think there's probably lines of the sand where I just wouldn't agree to certain things. So you just have to take a view on it, obviously. So yes, it's really, really important to get legal advice because dogs in the background.
It's fine.
It's really important to get legal advice because commercial leases are a really complicated area, and especially if the other side are represented, you don't want to be at a commercial disadvantage by not having, for the sake of a couple of grand of fees, 2 or 3 grand worth of fees, I would highly recommend you have a lawyer representing you.
Yeah, absolutely, because you're signing this for a long time. It's something you're committing into, and you need to make sure you're protected, don't you? Is there anything else that should be in the lease? Is there anything else that needs to be in there?
Well, I think there's lots of complicated provisions about insurance and who repairs in the case of fire or the property being destroyed, etc. I think that repair is really, really important. So in my experience, from a landlord's perspective, you really want to get the tenant to be repairing everything if you can. But obviously a lot of tenants see that as being difficult and expensive, so if they're responsible for a new roof or whatever. So you will find a lot of tenants in all spheres actually trying to mitigate their costs of spend on a property. So you need to be ready for that one, because their starting point will probably be the landlord repairs everything, and your starting point will be the tenant repairs everything. So there's gonna you have to kind of compromise.
I think commonly, certainly in the more residential properties, the providers very rarely will cover roof and externals, or the boiler. They're very commonly the things that fall to the landlord, I think, and then the rest they will pick up. But which
sounds probably quite sensible. So obviously when you go into that, you just need to understand what state the roof's in, what state the boiler's in, and just kind of understand those costs just in case that comes in as a liability later. So yeah, definitely repair. You definitely want to look at whether they can, it's called alienation, whether they can assign or sublet. What you don't want in that circumstance is to have a diluted covenant. You know, you might do a deal with a grade A tenant and they want to do an assignment or a subletting to a grade B or a grade C tenant, you know, in financially. And obviously, you've potentially got a bank who's going to be very interested in that. And C, you've got, you want to make sure you're going to get paid the rent, obviously, and you know you need to be doing all the financial checks and balances. Quite often you can't kind of say no to some of these things once they're in the lease. So you need to make sure that when you're actually putting the lease together, that you're absolutely sure what you're saying yes and no to, because if a tenant makes an application to assign or sublet the lease, it's quite often the landlord not to provide consent not to be unreasonably withheld or delayed. And so, you know, you don't want to be in a position where you can't say no because you've agreed a clause that you didn't really understand what you were agreeing, or you might have been too lenient at that particular point. So it's just worth kind of looking at that and making sure that you understand it.
So if it's assignable, say I let my property to a care provider who then can't maintain the service, doesn't get the contract renewed, they then sublet it to, I don't know, someone who's going to run the property as a bed and breakfast or something. That could happen if you assign it, and then you may not have the right to refuse that, like you were saying, unless it was looking like you were being unreasonable. But actually that could really mess up your lending if your lending is specifically for that and it doesn't allow, you know, Airbnb or bed and breakfast kind of provision within there. So I guess that's where you have to be protected.
Yeah, and this is where lease clauses all work together. So this is where you can control that through the user clause in the lease. So in the user clause in the lease, you'll probably have a planning class in there, but then you might want to say, you know, only to be used for you know, the use of supported living accommodation or whatever it might be. You've got to be really careful with the user clause because you don't want to restrict it so much that they can't do what they can't, you know, because actually if they want to dispose of it to another equal type of covenant who's still doing the same kind of business, you want to enable them to do that. But you just want to make sure that what you're doing isn't going to breach your lending or whatever. So you can control it through the user clause, but it can't be so restrictive that you know that it's going to affect the rent, because they'll say, well, we can't operate within that, so we want a rent reduction. So this is where commercial leases get a bit complicated, because you're kind of trading off different lease clauses. And you know, ultimately all the lease clauses have an effect on the rent. So if you as a landlord are trying to restrict something too much, an operator will look at it and go, well, I can't operate from that. You know, you're trying to restrict me so much, I can't operate from that, so I'm going to offer you half the rent I was going to offer, because you know, I can't operate my business as usual there. And obviously that's not in the landlord's interest either. So you have to, there's always a balance with these things. You want to have as much control as you possibly can as a landlord without restricting them so much that they can't run their usual business, really.
Really, really good advice there. And I think, you know, the key thing is, I know you've mentioned it several times, is getting good legal advice, isn't it, on these? Don't feel like you need to understand these entirely, you know, but make sure you've got someone who does understand them, who's helping you with it. Is there anything else that people need to think about? Is there anything else that we've not mentioned that you think is really key people know about?
Well, I think, so definitely get good legal advice. And it depends on the size of the deal you're doing and kind of what it is, where it is. But, you know, you can also get commercial agents to help you with this stuff as well. So whilst most commercial agents I know don't necessarily specialise in the support sector, they do know commercial leases. And what I tend to find with lawyers, unless you've got a really commercial lawyer, which do exist and are really good, by the way, like this is definitely not downgrading the advice from lawyers, because, you know, sometimes it can be fantastic. But if you've got a really pedantic lawyer that's not very commercial, you know, you can sometimes be at a disadvantage in negotiations, because, you know, they're trying to, and if you don't understand if you don't understand commercial leases much and you're saying, well, my lawyer's saying this, and you just not, sometimes you can be stymied so much by a non-commercial lawyer that you don't even get the deal done. So sometimes a commercial agent can unlock that, and they, you know, they're much more commercial, so they understand the commercial implications of it, and they also understand leases, so they can kind of strike some kind of balance between the two in terms of, you know, making sure you get the lease clauses you want, but also being commercial enough to say, well, actually, let's let that point go, because that's actually, in the scheme of things, not that important. We're much better to get this point over here because that's going to affect your rent or whatever.
And when you're talking about a commercial agent, where would people find one of those if they've just, you know, it's a property they own, they've got direct contact with their provider? Where would they find a good commercial agent?
So yeah, you can just so you can look up them on there's websites like Property Link Estates Gazette, Reala, the RICS, that you can find commercial agents locally. As I say, it's going to be challenging to find ones that specialize in this sector, but if you want advice on leases, they can certainly help. And you want to be kind of getting something called a professional surveyor, probably, so somebody who deals with rent reviews, lease renewals, etc. And then, you know, can kind of give you more commercial advice, because they deal with that day to day. And I suppose kind of the other thing that obviously the level of rent you may or may not be able to negotiate, and the you know, whether you can have these leases inflation linked with through rent reviews. I don't know from your experience how often you can get those, but I would imagine when it's a longer lease, 10 to 15 years, obviously your day one rent is going to in 15 years time is going to be completely outdated. So it's very, very common to have rent reviews, and there's a whole load of case law and everything around rent review clauses. And, you know, I would say out of pretty much everything in the lease, every lease clause is important, but you need to make sure you get that right, because that can really affect the level of rent you can get kind of throughout the term of your lease.
Yeah, absolutely. And I think it's something that the regulator of social housing is looking into. So for those who are working with regulated housing associations, I think it might be harder to get some of those rent reviews that previously have been available, but it's at consultation stage. So we'll see whether it's accepted, this legislation, or not, because I think that could have a big impact on people's leases and the value of them going forward. I think it's going to be interesting to see.
Yeah, I mean, I think that there's there's two main ways you can get rental increases. One is that you can just get fixed increases through the term, and that might be the way that you have to go if they start regulating it too much, so that everyone knows what their liabilities are from the beginning. You can use open market comparables, although they're limited with this kind of accommodation. So I think that's probably not the right thing to do. And obviously then you have CPI or RPI linked reviews, which would be more normal. And certainly in institutional leases, you know, the ones that pension funds will take on, or of this type of property, they would always expect to see annual increases, capped and collared at maybe 1% and 4%, or well, it used to be like that before inflation went to like crazy percent.
Scary numbers at the moment,
yeah, exactly. I don't think you're going to get away with 10% though, sadly, per annum. But you know, kind of, it would usually be capped and collared at around like 1 and 4, 1 and 5, 1 and 3, something like that. But yeah, it just depends what the regulator comes back with, really.
Yeah, it's going to be interesting to see where that goes. Thank you, Suzi. It's been really great chatting to you. I'll put your contact details in the show notes, so people who want to find you can come and find you there. And yeah, thank you very much.
Absolute pleasure. Great to see you.
Take care. Bye.
Thanks. Bye.